And Mr. Bass, when we took a recess there, just a moment to change the tape, we were talking about the role of the banks in the development of the state of Tennessee, and we were particularly talking about legal limitations on the rates of interest that banks could charge on their loans. Having served as a member of the First American Bank and also having a lot of banks for clients, how have you seen the development of banks in Tennessee over the period of your career?
Well, as you and I were talking about there was a geographical limit on where any bank could have a branch. And I don't remember whether it was, I think it was a county, but I could be wrong about that. So that, of course, inhibited a normal amount of growth which might otherwise have taken place. And when you had neighboring states which had no such geographical limits and which had unlimited or much higher interest ceilings than Tennessee had, when you put those things together, the banking industry in Tennessee was really hurting with the competition that they had from surrounding states.
The North Carolina, for example, and Alabama both have right now, as we're talking in 2005, they have huge banks, big banks in both of those states. And do you know whether or not those states had more flexible banking laws that allowed the growth of the national banks?
Well, they all varied, but yes, on the whole, most of them were very much more lenient towards growth than our laws.
Why was Tennessee unable to? What were the hurdles that were facing the banks in terms of growth? Why could they not get legislation through the General Assembly to allow more flexible laws?
Well, legislators were toward interest rates just like public service commissioners were toward rate increases. They just didn't, they were just difficult to get.
Right. What about other cases that we've talked a little bit about the rate cases for South Central Bell, talked a little bit about banking law developments in the state. What other cases of interest do you remember fondly as a part of your career?
Well, one that probably had more national significance than any other never was tried. It was settled, and that was also a telephone case, but wasn't a rate case. In the early 1950s, I think it was 53 or 55, the Communications Workers of America struck against Southern Bell. And it was quite an extended strike with a great amount of violence and intimidation, property damage. And when it was finally settled, Mr. Fred Turner, who was the chairman of Southern Bell, and Mr. E.D. Smith, who was the general counsel of Southern Bell, decided that they wanted to bring a lawsuit against the Communications Workers of America. Not that they had the expectation of recovering a lot of money, but if they could send the proper message that the next time they had a strike, that they would not have to suffer quite so heavily. And they kicked the idea around a good deal, and I went down to Atlanta and talked to them about it, and they finally decided that, somewhat over the opposition of members in the legal department, that they were going to bring that lawsuit. And they asked me if I would bring it. And I said, well, yes, I'll bring it for you if you want it. But it's going to be very, very expensive. After all, we were going to have to take depositions in 9 states. And not only is it going to be expensive, but if you think about it, it was almost impossible to pick a jury of 12 men who don't have some labor connections. So I'm not guaranteeing any result for you. I'll bring the lawsuit and I'll do the best I can with it. Now, with those caveats, if you say go, we're going to go. And they said go, so we went. And I filed that lawsuit. And we took depositions in 9 states. We got police records, of course, the telephone company records, and we had the thing all set, not all set, but almost all set, ready to go to trial, when all of a sudden the communication workers realized, you see, that we were serious about it. Therefore, they had been threatened with lawsuits, but when the strike was settled, those things all just vanished. And they found out this time that it was for real, and so they started trying to settle the case. And I never would talk to them because I knew they weren't going to pay us very much. And they had a lawyer named Adair who knew Mr. Sims. See, Mr. Sims was our labor lawyer at that time. And he was back from this was several years after his heart attack. Adair got hold of him and said he wanted to talk to him about settling that case. And I said, well, talk to him. Let's see what to say. So he did, and they dickered back and forth, and then finally the union offered him $300,000. Well, that wasn't near enough, but we had to present it to the clients, and the client said, that's all right, we'll settle it. What we have done is send a message to them that we wanted to send to them, and therefore the case is worth a whole lot more to us than the $300,000 we're going to get out of it. So we did settle it, and it was in every newspaper in the United States that Southern Bell had recouped from the union compensation for the damage and the damage to the property and the violence, and it really got a lot of national publicity and commendatory, because most of the news media, strangely enough, seemed to be on the side of the capitalists.
Mr. Bass, I wanted to turn a little bit to the development of Bassberry and Sims over the period of your career from 1922 with 4 or 5 lawyers to now over 160 lawyers in 3 cities, Memphis and Nashville and Knoxville. What do you attribute the development of the firm, the growth of the firm over those years to?
Oh, well, I don't think there's any secret about that. I mentioned earlier, I think, that back when nearly every lawyer was a general practitioner, but now the sun had set on them because everything's specialized. When you get that degree of specialization, which didn't happen overnight, but it happened over a relatively short period, you have to grow if you're gonna represent your clients, and so that is the main thing I think that prompted the growth of the firm that we've got.
What advice would you have for young lawyers starting out practicing law these days? Maybe top 3 things that you would recommend to them to develop a good, successful, healthy law practice.
Well, if they want to try lawsuits, they ought to be a litigator. If they're not going to try lawsuits, I've always said if I came back in another life, I'd be a tax lawyer, because that's where the dough is.
You want to wade through all those 10 shelves full of IRS codes and everything?
Well, I've waded through a whole lot of law books.
What about litigators? For young litigators, what would you advise them? Young men and women who want to learn to try cases. What are the keys?
Well, there's no substitute for experience, and they have to do just what I did. I tried to get that experience before I had any cases to try. I was observing how recognized able lawyers tried a lawsuit. And then too, I had one of the best people in Mr. Sims that anybody could work with, and I worked with him very closely for 34 years.
What were the things that you most admired about Mr. Sims?
Well, he had a sense of humor that wouldn't quit. He was always buoyant, happy. He was extremely careful about everything he did legally. If he couldn't go down one path, he went down another one. He had a way of, he could talk to you on any subject. He was just one of those people that you don't run across every day in life. He was a remarkable man.
He died in 1968.
1968, he's 75 years old.
As law firms have grown and specialization at the bar has grown, it's sometimes seems to be more difficult for lawyers to get along together smoothly and effectively and efficiently. There seems to be more impersonality, more impersonal relationships and so forth. When you were practicing at the bar for many years, you knew all the lawyers, and it seemed like there were good relations with the lawyers, and you could trust a lawyer with their word. They told you they're going to do something, you trust some of them, and they would do it. You didn't have to put everything in writing. How would you advise those of us who are practicing in an era of larger law firms where the members of the bar don't know each other as well? How can we get along better? How can we be more effective for our clients and yet still be agreeable to each other?
Well, Lee, I don't know that there is any way to return to what it it used to be. When I started practicing law, we didn't. Any time a lawyer told you anything, you knew who he was, and you knew that he do what he said he's going to do. And it was just much more of a understanding relationship among all the members of the bar. Now, you got to remember that we didn't have the numbers we got now. I think I was the president of the Nashville Bar in 1952. Well, I'd been practicing 18 years then, and we only had, I'd say, 200, 250 active lawyers. And I knew most of them. But you can't do that today. I don't think there is any way to return to it.
Yeah, I think I was president of the bar, Nashville Bar, in '85, and we had about 750, 800 lawyers, and now we have 2,000, over 2,000 lawyers at the Nashville Bar, and then 7,000 or 8,000 across the state, maybe even more than that through that time.
I don't think there's any way to get back to what it used to be.
When we interviewed Woody Sims here a few months ago, maybe it was last year, one of the questions I asked him was, Woody, what do you do around here? And Woody very charmingly said, quote, they still pay me something, but I don't do anything around here. What are you doing around here these days, Mr. Bass? Well, maybe I should ask. Maybe I should answer that question, but you try.
Same thing. I think they're very tolerant. Let me come in here every day, and they give me a secretary and got a computer that I don't use.
Well, I'll say this, because I'm one of the many lawyers who come into your office early on to ask you advice on cases and particularly tough judgment issues and tactical decisions, and you've always been right on the top of your game and always have an open door, and have always been willing to talk with young lawyers, and we are grateful for that. Is there anything, well, let me ask you a couple of other questions as we wrap this thing up. What would you say were the rewards and the advantages of the legal career that you've had? What are the things that you have found most rewarding?
Well, I think your relations between your fellow lawyers is a very important factor. And of course, I haven't known anything else. Your generation, I wish could get back to the same thing, but I don't think you ever will. I don't really know, Lee, how to answer that.
What about the difficulties of the law practice going forward? One of them, the size of law. That's certainly one of them. Are there any other challenges that you see that lawyers today face?
Yeah, one of the things that really disturbed me about the practice of law now is the idea that personal responsibility is an extinct concept. We don't have any personal responsibility for anything. Everybody is a victim of somebody else. And I think it has led to universal disrespect for the legal profession. It's not all the fault of the lawyers. I think some of the judges have spurred that along. After all, when you get somebody and order a hot cup of coffee and then turn it over in their lap, and it's your fault because you cooked the coffee. That's crazy. And I also think that the way that the threat of punitive damages has been handled to effect enormous settlements, I think that's very deplorable, and that's another reflection on lawyers. It's, you know, law used to be about the most highly respected profession that you could be in. And it really disturbs me that your generation and subsequent generations are going to have a terribly hard time ever regaining that kind of respect. It has been an imposition by a relatively small group of lawyers, which they have imposed upon lawyers in general, and I resent that.
We've had a wonderful chat this morning. We appreciate it. The Tennessee Bar Foundation appreciates it very much, and I wanted to ask you if there's anything further that I've not asked you that I probably should have asked you.
No, I don't think you've failed to cover pretty much all the territory.
Well, you are for sure a titan of the Tennessee Bar, and we're grateful for your time today.
Well, thank you. It's a pleasure to be here.